make our contribution.
Doreen will collect from you.
Okay.
And,
just want to say hello, man. Joe Stanfield.
Hey, Joe.
It's a pleasure to meet you. It really is. It really is. Appreciate everything that you've done. I really want to make sure you know that I know that.
Appreciate that. Appreciate that a lot. Okay. Doreen is up there, and go ahead and everybody do name tags, please.
Yes, have name tags up here that I'd like to
Give Doreen your $5 for the room, and then find yourselves a seat. Okay, get started. As I mentioned to everyone earlier, who was here at the time, I like to open these events with a reading of what I like to think of as the proper American Pledge of Allegiance. This is not a Pledge of Allegiance written by a socialist, which the standard one that you're all familiar with was. Bellamy was, in fact, a very dyed-in-the-wool socialist, and he wrote his thing kind of intending to create a little something that would infest the minds of Americans going forward, overcoming the doctrine of state sovereignty. This pledge, on the other hand, invokes the principles, the founding principles of our country as enunciated by Thomas Jefferson in the Declaration of Independence. And this is the one that I would like to have living in the minds of every American. And so I'm gonna recite it, and I hope you all will join me here. And it starts out with, I pledge allegiance to the principles of the United States of America, holding that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. I hold further that it is to secure these rights that governments are instituted among men, deriving their just powers from the consent of the governed, and that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Hear, hear. And I say it that way because I want the restoration of liberty and the rule of law in my lifetime, and I hope that every one of you wants that too. Incrementalism is for other people, in my view. I want everything to which I'm entitled, and I'm entitled to liberty. It's the way I was born, and it's really the way I would like to die. I don't live that way right now, unfortunately, because we don't have that too much in this country right now. But I sure hope that by the time I pass, we do, and my kids do. So, I like to remind people, just disregard the books, that's not the point here. The point is that we are needing a Second American Resolution, and that's as distinct from a revolution. And the meaning of that is found in John Adams' words down here. What do we mean by the American Revolution? Do we mean the war? Do we mean the revolution, quote unquote? No, the revolution was effected before the war commenced. The revolution was in the minds and hearts of the people. The revolution that Adams is speaking of is the resolution that American colonists made in that time to be free of arbitrary rule. It was in their heads and in their hearts that they made the choice. They then went out and took up arms and did the fighting and secured that liberty. But it was the decision to have that liberty that was the real revolution. And we need here that same thing again, I believe. We need that same resolution to be free again. So, unfortunately though, in the early part of the 20th century, we had a counter-revolution against the revolution that Adams was speaking about. It took place in 1776 and several years afterwards. A American liberty and the rule of law were assaulted on many fronts in the early part of the 20th century. The most far-reaching and harmful of these assaults was the subversion of constitutional taxation provisions so as to open up a river of wealth flowing from the pockets of its producers into the hands of an increasingly permanent political class and its oligarchic owners. This assault, supported by a massive misinformation campaign, took the form of an institutional pretense that the benign and constitutionally respectful income tax had been authorized by the 16th Amendment to be administered as a non-apportioned capitation. And we're going to get into what those terms mean. The effect of this ignorance tax scheme in facilitating the revenue and corresponding growth of the state is dramatic, as is vividly shown in this graph charting the growth of the federal government, in which we can see from the origin of the adoption of the current constitutional form in 1789. This chart has around through 2004. You can see that for the first 140 years or so, we had basically the stick of the hockey stick, right? Not the blade. It was just basically a flat line. Government at all levels, federal, state, and local combined, averaged less than 10% of GDP. It absorbed virtually nothing. By today's standards, it absorbed virtually nothing. You have no idea. It was said, it was written back around the turn of the last century, in the 1900s by a writer, and he was a conservative fellow, that at that time, and surrounding that time, Americans would go through their entire lives with contact with only one single federal official during that entire span of their lives. And who would that have been? The guy that delivered their mail. That's it. There was no other federal government in most of these lives. It simply didn't exist. It was a tiny, tiny little thing doing its constitutional responsibilities for the most part. It's not perfect by any means, but again, measured by today's standards, we see the blade of the hockey stick. Starting in about 1943, when the income tax misunderstanding was cemented and began being exploited, we see the blade of the hockey stick erupt. And now we're in a position where state, local, and federal governments eat up something over 50% of GDP. It is a dramatic difference. And it is more of a difference than just the numbers. It's more of a difference than just the percentages. It's more than just that 5 times as much of the wealth produced in the country is now absorbed by and spent by government. It is the things that are done with that money that have far-reaching effects that control the lives of other people. They control the lives of you folks, of us, of Americans. They dictate our behavior. They dictate our decisions. It goes far beyond just a matter of the money. It's a power issue. And it always has been a power issue. I mean, money is important to the people who end up, with it in their pockets, but the power is just as important. And when you lose the money, you lose the power. When they gain the money, they gain the power too. So this is what we've seen happen as a consequence of the misunderstanding of the income tax in particular. Now let's look at what the income tax really is. And for those of you that are first-timers here, this is going to seem very, very strange, I think. I'm going to urge you to pay close attention. Anybody here ever actually gone through the trouble of like checking me, looking into the law yourself and making sure that what I say is actually what you see when you look at those court rulings and when you look at the legal actions? Can I show of hands here? Okay, fair number of people. I encourage people to do that. Those of you who are new here, please be encouraged by that as well. What you're about to see is the real deal. It's going to be completely different from what you have been led to believe. Completely different. And we're even going to get into showing some dramatic and blatant lying done by federal officials, the sort of people that you've been encouraged to imagine don't ever lie to you, and that are paragons of virtue. And in fact, they're the final word on what the truth is in this country, particularly in regard to its legal structure. You're going to see that these people lie in some cases, and an important thing. So let's follow along here.
The
income tax is an excise tax arising only upon the happening of distinguished taxable events. Income tax is an excise and applies only to objects suited to an excise. It is not and cannot lawfully be imposed as a capitation or other direct tax. And again, we're going to get to the meaning of that one in a moment. This is settled law in the United States, being expressly declared and reaffirmed by the United States Supreme Court, both before and after the 16th Amendment, repeatedly and consistently. Here's the Brushever versus Union Pacific Railroad Supreme Court, in 1916, in the case in which the meaning and effect of the 16th Amendment was considered by the court. The court ended up rendering a unanimous decision, and it said some really significant things. Among them, taxation on income is, in its nature, an excise, entitled to be enforced as such. And in doing so, it was repeating the Supreme Court of 1895, which had said exactly the same thing. It goes on to say, we are of the opinion, this, unfortunately, the Brushever court was, the Brushever opinion was written by Chief Justice White. White was a kind of a voluble fellow. He spoke great rotund terminology and 100-word sentences, and so the best thing that can be had from him in some cases are statements that from which information needs to be derived, and this is one of them. We're of the opinion, however, that the confusion is not inherent, but rather arises from the conclusion that the 16th Amendment provides for a hitherto unknown power of taxation, that is, a power to levy an income tax which, although direct, should not be subject to the regulation of apportionment applicable to all other direct taxes. And the far-reaching effect of this erroneous assumption will be made clear by generalizing the many contentions advanced in argument to support it. The reason the court said that is because the challenge that was being made by Frank Brushever in this case was an assault on the revived income tax under an act of 1913, just after the 16th Amendment was adopted, in which Brushever argued that this tax, because it lacked apportionment, in other words, it wasn't being apportioned among the states the way direct taxes and capitations are required to be under the Constitution, was therefore unconstitutional. So he was saying this is a direct tax, and yet it's not apportioned, therefore it has to be struck down. The court's saying you're wrong, it's not a direct tax. That's the key part of this ruling. The Brushever court goes on to point out that the very suggestion of a non-apportioned direct tax, whether on incomes or anything else, is completely incoherent because it would cause one provision of the Constitution to destroy another. That is, it would result in bringing the provisions of the amendment supposedly exempting a direct tax from apportionment into irreconcilable conflict with the general requirement that all direct taxes be apportioned. This result, instead of simplifying the situation and making clear the limitation on the taxing power, which obviously the amendment must have been intended to accomplish, would create radical and destructive changes in our constitutional system and multiply confusion. Now, you don't have to have followed that closely. We're going to get to coherent, very concise summaries of this as we go on. The Supreme Court, a month later, this same Supreme Court, in Stanton versus Baltimore Mining Company, had the same subject arise, the meaning of the 16th Amendment, and so it reiterated what it itself had just said a month ago in the Brushever court. Here, we don't have something written by Chief Justice White. Here we have something written by another justice who was a much better speaker and was much more concise in saying the key and important things here. So, the Supreme Court reiterates the Brushever holding repeatedly over the decades. In Stanton v. Baltimore Mining, it says, by the Brushever ruling, it was settled that the provisions of the 16th Amendment conferred no new power of taxation, but simply prohibited the previous complete and plenary power of income taxation possessed by Congress from the beginning from being taken out of the category of indirect taxation to which it inherently belongs, and being placed in the category of direct taxation subject to apportionment by a consideration of the sources from which the income was derived. That is, by testing the tax, not by what it was, a tax on income, but by a mistaken theory deduced from the origin or source of the income tax. That's the dealing here with the subject of the source issue that arises in the 16th Amendment, which the amendment provides that Congress can lay a tax on incomes, and by the way, it is incomes with an S at the end in the 16th Amendment, not income, from any source derived without regard to apportionment. And the source that's being referred to there is the source that the Pollock court had settled on in 1895 as a way of nobbling the taxes application to two different things, dividends and rent, on the basis of the reasoning that dividends and rent proceed from personal property. Dividends proceed from stock, which is personally owned, rent proceeds from real estate, which is personally owned. And because of that personal source connection,
on what this meeting is.
when the tax is applied to those two types of things, it isn't actually an excise, an income excise any longer, it becomes a property tax. And property taxes are recognized direct taxes, requiring a portion. And so the court said at that point that the 1894 revival of the 1862 income tax, which applied the tax to dividends and rent, just as it always had, since the tax always had. But based on an argument being brought by Charles Pollock, they decided that the tax constituted, and in those two cases, constituted a property tax and had to be apportioned. So they struck down 10 sections of a much, much larger 1894 Revenue Act in which the income tax was being revived after having been put to sleep basically in 1872. The Bruce Report says that the 16th Amendment, in overruling the Pollock decision, simply said that resort can't be made to the source argument to protect those two things, dividends and rent, the two things that have been relieved of the tax by the Pollock Court. That argument no longer exists. That's all the 16th Amendment does. All the 16th Amendment does is it eliminates a blockage of the application of the tax to dividends and rent on things which otherwise were excise taxable, which is what the Stanton Court says here. Here's another Supreme Court ruling, 1937. This is Stewart Machine Company versus Collector of Internal Revenue. If a tax is a direct one, it shall be apportioned according to the census or enumeration, which is to say, that's still true, even though, in this case, the court is speaking 24 years after the 16th Amendment. If it is a duty, imposed or excise, it shall be uniform throughout the United States. Together, these classes include every form of taxation, of tax appropriate to sovereignty. Prior to that specific language, by the way, the Stewart Machine Company court said specifically, the income tax does not qualify as capitation. In South Carolina versus Baker in 1988, the Supreme Court again addresses the question. It says the sole purpose of the 16th Amendment was to remove the apportionment requirement for whichever incomes were otherwise taxable. It was not a removal of the apportionment requirement for income as a generic item, as a, generally, for incomes which otherwise qualified for the tax. The apportionment requirement was removed. Didn't mean that the tax became a direct tax, as all the other courts have said. This does not make it a direct tax. It simply means that the Supreme Court, in the Pollock decision, had applied an apportionment rule to certain types of income, and the 16th Amendment removed those. Contemporaneous and subsequent analysis by both private executive branch and legislative branch experts acknowledge the Bruchber ruling as settled law, to which all courts and agencies are subject. As the Cornell Law Quarterly in 1916, reviewing the Bruchber decision, said the 16th Amendment, this is the Cornell Law Quarterly explaining what the Bruchber Court said. The 16th Amendment does not permit a new class of direct tax. The amendment, the Supreme Court said, judged by the purpose for which it was passed, does not treat income taxes as direct taxes, but simply remove the ground which led to their being considered as such in the Pollock case, namely the source of the income. Therefore, they are again to be classified in the class of indirect taxes to which they by nature belong. I'm hoping that everyone is following this one key point here with these various authorities that we've looked at, which is that they are all consistently declaring that the income tax is not a direct, non-apportioned tax. Is that coming clear? Is everyone following that? Okay, let's continue. Here's the Harvard Law Review in 1916, also reviewing the Bruchber Court decision. In Bruchber versus Union Pacific Railroad Company, Mr. Chief Justice White, upholding the income tax imposed by the Tariff Act of 1913, construed the amendment as a declaration that an income tax is indirect, rather than an exception to the rule that direct taxes must be apportioned. Very clear and concise statement of what I've just been saying, yes? Everyone follow that, okay? It is not a direct tax spared from the apportionment requirement. It is an indirect tax. It remains an indirect tax. House Congressional Record, March 27, 1943. This is the testimony of Treasury Department legislative draftsman F. Morse Hubbard, speaking to Congress. The income tax is an excise with respect to certain activities and privileges, which is measured by reference to the income which they produce. The income is not the subject of the tax, it is the basis for determining the amount of tax. We'll get into that a little bit later. Morse goes on to say, or Hubbard, I'm sorry, goes on to say, the amendment made it possible to bring investment income within the scope of the general income tax law, but did not change the character of the tax. It is still fundamentally an excise or duty. In 1979, Howard Zawitsky, the legislative attorney at the American Law Division of the Library of Congress, published a pamphlet at Congress's request explaining some issues, some legal issues, amongst them the income tax and elements of the income tax. It says this: the Supreme Court, in a decision written by Chief Justice White, first noted that the 16th Amendment did not authorize any new type of tax, nor did it repeal or revoke the tax clauses of Article 1 of the Constitution, quoted above. Direct taxes were, notwithstanding the advent of the 16th Amendment, still subject to the rule of apportionment. So, again, everyone's following this. The income tax is not a direct tax, spared the apportionment requirement. It is an indirect tax. It is an excise tax.
Can you explain apportionment?
Income tax return forms, both before and after the 16th Amendment, acknowledge the excise character of income taxation, and that taxable income is a distinguished subclass of what comes in, rather than all that comes in. Here's the affirmation for the very first income tax form for the 1862. I hereby certify that the following is a true and faithful statement of gains, profits, or income of so-and-so, of the such and such, in the county of such and such, in the state of such and such. Whether derived from any kind of property, rents, interest, dividends, salary, or from any profession, trade, employment, or vocation, or from any other source whatever, from the first day of January to the 31st day of December, 1862, both days inclusive, and subject to an income tax under the excise laws of the United States. Any doubt here? The income tax is an excise tax. In 1916, after the Bruchner decision, which established the meaning and effect of the 16th Amendment, I swear or affirm that the foregoing return, to the best of my knowledge and belief, contains a true and complete statement of all taxable gains, profits, and income received by me during the year for which the return is made, as opposed to simply a complete statement of all gains, profit, and income, which would be the other way of putting it if it actually applied to everything. The income tax is an excise. Congress says so, the executive says so, the Supreme Court says so. All also affirm that to be subject to the tax, or a measure of the tax, any given gain must be distinguished by connection with taxable events or activities. The income tax is not a tax on all that comes in. Instead, because the tax is an excise, as Bruchner actually and unmistakably rules, and as the Supreme Court repeats many times over the decades, someone's earnings could only qualify as taxable or as a measure of tax liability if they are products of privileged activities. Let's look at Thomas versus United States, 192 U.S. 363 in 1904, Supreme Court saying, and in Flint versus Stone Tracy, Supreme Court saying, as was said in the Thomas case, the requirement to pay excise taxes involves the exercise of privileges. The privilege element, and in fact, let's look at the footnote here in this piece. Case law recognizes no distinction between a privilege tax and an excise tax. Whether the tax be characterized in the statute as a privilege tax or as an excise tax is but a choice of synonymous words. For an excise tax is an indirect or privilege tax. The terms excise tax and privilege tax are synonymous, and the two are often used interchangeably. Okay? Is that clear? An excise is a privilege tax. The income tax, as we have seen, is an excise tax. Therefore, the income tax is a privilege tax. Okay?
Are you quoting the Supreme Court saying that just now?
What I just said?
What you just said?
I just summarized everything that we just looked at. We've looked at the Supreme Court making clear that the income tax is an excise tax. We've looked at the Supreme Court making clear that an excise tax is a privilege tax. Therefore, the income tax, the income excise, is a tax on privilege.
Gotcha.
Okay. The privilege element of the income tax is established independently of the legal character and constraints native to excises as well. Okay, we've just seen that excises are privilege taxes, but we can tell that the income tax is a privilege tax on another ground as well. A tax on or measured by unprivileged receipts is a capitation. Here's Pollock versus Farmers Loan and Trust. This is the Supreme Court in 1895, and probably the most comprehensive analysis of tax law, this constitutional tax law in the United States in its history. It wrote something along the lines of a 195-page analysis over the course of 2 separate rulings and 2 separate occasions on this one case. And in it, it said this. Albert Gallatin, in his Sketch of the Finances in the United States, published in November 1796, said, "The most generally received opinion, however, is that by direct taxation in the Constitution, those are meant, or by direct taxes in the Constitution, those are meant which are raised on the capital or revenue of the people." He then quotes from Adam Smith's Wealth of Nations, and continues, "The remarkable coincidence of the clause of the Constitution with this passage in using the word capitation as a generic expression, including the different species of direct taxes, and acceptation of the word peculiar, it is believed to Dr. Smith, leaves little doubt that the framers of the one had the other in view at the time, and that they, as well as he, by direct taxes, meant those paid directly from, and falling immediately on, the revenue." Here's how Adam Smith defines capitations. This is just a summary. This was out of a chapter of his book. He wrote a chapter focused on this subject. Here's the excerpts put together. "The taxes which it is intended should fall indifferently upon every different species of revenue are capitation taxes. In the capitation which has been levied in France without any interruption since the beginning of the present century, people are rated according to what is supposed to be their fortune by an assessment which varies from year to year." Does that sound familiar? In the first poll tax, some were assessed at 3 shillings in the pound of their supposed income. Yeah, that sounds familiar because that's the experience that we all have today of the income tax. But that's exactly what the Supreme Court says is a capitation. And the Supreme Court says, as you have seen, that the income tax cannot be, it is not a capitation. It is not capitation. And yet, that's how we experience it here today. Is that because the Supreme Court was wrong? It's not. You get there. Capitation, a poll tax, an imposition which is yearly laid upon each person according to his estate and ability. This is from Bouvier's Law Dictionary in 1856. This was the official law dictionary of Congress when the income tax was initiated. They knew what a capitation was, and they knew what they were not imposing. Capitation, Burton's Law Lexicon in 1884. Capitation, a tax or imposition raised on each person in consideration of his labor, industry, office, rank, etc. It is a very ancient kind of tribute and answers to what the Latins called tributum, by which taxes on persons are distinguished from taxes on merchandise, called vectigalia. Further, taxes on the exercise of rights are inherently direct, regardless of the label put upon them. As the Supreme Court says in Knowlton v. Moore, quoting a French specification, direct taxes bear immediately upon persons, upon the possession and enjoyments of rights. Engaging in unprivileged economic activity and receiving and enjoying the fruits therefrom is a right. As the Supreme Court says in Butchers Union Company versus Crescent City, in 1883, the right to follow any of the common occupations of life is an inalienable right. It has been well said that the property which every man has in his own labor, as it is the original foundation of all other property, so it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing this strength and dexterity in what manner he thinks proper, without injury to his neighbor, is a plain violation of this most sacred property. He's quoting Adam Smith in Wealth of Nations. Again, in 1915, the United States Supreme Court in Coventry, Kansas says this: included in the right of personal liberty and the right of private property, partaking of the nature of each, is the right to make contracts for the acquisition of property. Chief among such contracts is that of personal employment, by which labor and other services are exchanged for money or other forms of property. working for a living, trading your labor for pay or anything else is your right. It is an unalienable right. The Supreme Court says it absolutely plainly, and as we saw a little earlier, the Supreme Court says taxes on rights are direct taxes. If you're going to tax a right, you have to do it through apportionment. And I'll get into what apportionment means now, because a few people have questions about that. Apportionment was a rule that was put in place in the Constitution in order to discipline the federal government's reach into the pockets of citizens. The colonists and the founders were very, very tax sensitive. They were themselves, they were subject to at one time as much as a 3% total tax burden as colonists, and they viewed that as an outrage. They viewed it as a revolutionary outrage. They got their muskets over that, among other issues. But 3% was considered to them was considered diabolical in nature. It was absolutely horrendous and not to be tolerated. They took taxation very seriously. They recognized that taxation is the thing that determines who's in charge. The one who has the money, they have the power. They wanted the people to have the power. And so they wanted the people to keep their money. It was as simple as that. So they imposed some rules on the way taxes could be done. In the very first formation of the Constitution, known as the Articles of Confederation, they didn't allow the federal government to tax at all. It had no revenue-raising capability at all. It could apply to the states for grants, for gifts, donations, basically. And that was it. It had no power to impose any kind of taxation, even on its own stuff. It couldn't demand anything from anybody in the way of money. When the Articles of Confederation were revised in the 1787 Constitutional Convention and adopted eventually in 1789, some limited power of taxation was granted. It was subject to some rules. And one of them was the apportionment rule. And that said that anytime if Congress wanted to impose any kind of capitation, in other words, just go at people for economic activity, go at people just for making money, receiving money, they had to do it through the apportionment mechanism. Apportionment means to establish the overall total of what the tax was going to be. And just as an example, I'll say $1 million. Okay, so Congress says we want to we need $1 million, and we're going to impose it on people's economic activity, and therefore we have to apportion it. And apportionment means we're going to divide the million and impose it upon the states, with each state being required to pony up their percentage of that million as a ratio of their percentage of the population. So if Maryland at the time had 10% of the population of the country, Maryland was responsible for 10% of the million. Maryland had to pony up $100,000. And it was Maryland that had the tax imposed on it. It wasn't the people in Maryland. I mean, ultimately, of course, the linkage is there, because Maryland itself has no money. It gets its money from the people of Maryland. But Maryland was the entity that the tax was laid upon. That's what apportionment means. It's the establishment of a number that is derived at, say Congress decided to put a $10 tax on windows, which would be a direct tax. It's tax on property. Then they would add up all the windows in the country, and they'd multiply by 10. And that would be the amount of tax. And then they would take that tax, and they would divide it amongst the states based on each state's proportion of the national population. And there are a bunch of virtues to this. For one thing, these taxes are one-time taxes. You do that math one time. You add up the windows, and you multiply by 10, and you come up with a figure, and you impose the tax one time. If you want more money, you have to go through that process again. Congress has to do a lot of voting. It's very transparent. Another thing is you can only impose that tax in a fashion that the least prosperous state is going to be able to handle. You can't do this in a fashion where, we have a bunch of rich people, and we're just going to, we're going to have money generally. The way this, current income tax plan operates. And these people will just, it'll be pouring out of their pockets all the time. No, in the case of an apportioned tax, it's, whoever has the least is sort of the controller of just how much tax can be imposed. So it's an equilibrium imposing and a restraint imposing structure of taxation. Very important. So that's what apportionment is. Okay. Moving on with the rights issue. This is Jack Cole Company versus McFarland. This is in the Supreme Court of Tennessee, 1960. Since the right to receive income or earnings is a right belonging to every person, this right cannot be taxed as privilege. Okay? Follows directly on everything that we've seen so far. Very concisely said. In the Supreme Court of Arkansas, in 1925, delivered an opinion, in this case Sims v. Arons, which is a remarkable opinion in that the passage quoted here is included. Because it says things in a way that is rarely expressed. Not likely to see this in too many places, but it says really, really important and key things very, very clearly. And so I'm going to read it, and I'll end up reading it again. I want everybody to pay real close attention to the language here. You're going to see some tricky things said in this passage, if you haven't already studied this work. Although the legislature may declare as privileges and tax as such for state revenue purposes those pursuits and occupations that are not matters of common right, the legislature has no power to declare as a privilege and tax for revenue purposes occupations that are of common right. The right to engage in an employment, to carry on a business, or pursue an occupation or profession not in itself hurtful or conducted in a manner injurious to the public is a common right, which under our Constitution as construed by all our former decisions can neither be prohibited nor hampered by laying a tax for state revenue on the occupation, employment, business, or profession. Now, follow along closely. Thousands of individuals in this state carry on their occupations as above defined, that is to say, businesses, pursue occupations, professions, and so forth, carry on their occupations as above defined, who derive no income whatever therefrom. But where an income is derived from any occupation, business, profession, or employment, then the legislature may lay thereupon the tax. Now, did everybody notice the interesting thing there? The court is saying, Supreme Court of Arkansas here is saying, thousands of people carry on their businesses, their occupations, their work, and so forth, and derive no income whatever therefrom. What are they saying? Income is not money that you make, or that you get paid for working, or from your business, or anything else. They're drawing a distinction, clear as day. They're drawing a distinction here, saying there is the kind of gain that we can call income, and tax as they go on to express. And there's the kind of gain from the same things, same kind of gain, exactly the same kind of thing, that is not income and not subject to the tax. Okay? You're not often going to see it put as clearly as that. The Supreme Court of Arkansas saying there is the taxable stuff and there's the not taxable stuff. They're basically the same thing. They're from businesses and occupations and professions and work. All the same thing, but one of them is a taxable kind, and one of them is not.
What differentiates it, Chair?
Privilege. Privilege, as it says in the beginning. We can tax for privilege things that are not of common right. And that's the definition of a privileged activity. If you only can do it because somebody has to give you permission to, that's privilege. That's exercise privilege. If you're doing it for common right, if you're a plumber, you own an auto repair business, or you're an artist, or you're an IT guy, or whatever you do. If you don't do it for, in the case of the income tax, for the federal government, frankly, you're not exercising privilege. You're exercising your rights. You're doing what you're entitled to do. You're entitled to do what the government wants you to, or not what the government allows you to, or not. They don't have a right to stop you. We saw that in Butchers Union versus Crescent City Company in Cottage v. Kansas. You have a right to do the things that you do. You can't be taxed for it. And so the argument here is very, very clearly expressing this fundamental reality of the tax. And I hope that those of you that are new here are paying really close attention to this. Capitations and other direct taxes are prohibited unless apportioned. There's the United States Constitution, Article 1, Section 9, Clause 4. It's in the Constitution in another spot as well, by the way. That's the only thing that's in the Constitution twice, by the way. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before direction to be taken. Period. As has been exhaustively shown, this constitutional rule has never changed, and the 16th Amendment in no way authorized a non-apportioned capitation or other direct tax, right? We all remember that from the early part of this presentation, right? The 16th Amendment did not authorize a direct non-apportioned tax, right? That's what the courts and all the authorities, the legislative craftsmen, the Congress, everybody said it's an excise tax. It is not a unapportioned direct tax. In fact, they specifically said, this is specifically what the Bruce Report in particular rules, it is not a non-apportioned direct tax. As has been exhaustively, okay, I've said that already. 16th Amendment no way authorized non-apportioned capitation or other direct tax. Hence, the unapportioned income tax cannot and does not fall indifferently on every different species of revenue, as in Adam Smith's definition of capitation. It does not fall indifferently on every different species of revenue. It only falls on revenue distinguished by its connection to an exercise of privilege. You have distinguished revenue, and you have undistinguished revenue. The kind that the income tax falls on is distinguished. It's a special kind. The limited scope of the tax is actually authorized, written, and ruled upon is interestingly underscored by recent corrupt efforts by certain members of the federal judiciary and executive branch to claim that Bruchmer holds that the 16th Amendment authorizes a non-apportioned direct tax. I'm going to ask you all to remember what we saw that the Bruchmer court actually said, and what we saw the Stanton court a month later, the exact same court summarizing the Bruchmer court decision to be, and what we saw Cornell Law Review in 1916 review the Bruchmer decision to be, and we saw the Harvard Law Review review the Bruchmer decision to be, and we saw F. Morse Hubbard, the legislative draftsman in 1943, testifying in Congress to what the Bruchmer court said about the 16th Amendment, and we saw what Howard Zaritsky, the law librarian of the Law Division of the Library of Congress, said in 1979 about what the Bruchmer court said, and we saw what the Supreme Court said in Seward versus Seward Machine Company about what the Bruchmer court said, and we saw what the Supreme Court said in South Carolina versus Baker in 1988 about what the Bruchmer court said. Okay, we all remember that. What they all said, the Bruchmer court said, the 16th Amendment does not take the tax out of the class of indirect taxes and create some kind of direct non-apportioned tax, right? What all of these authorities said. Here's what the 8th Circuit said in the United States versus San Francisco in 1980. It said the income tax is a direct tax. See Bruchmer versus Union Pacific Railroad Company. The purpose of the 16th Amendment, this is what the Francisco Court says, the purpose of the 16th Amendment was to take the income tax out of the class of excise and imposts and place it in the class of direct taxes. That's actually a quote from the Bruchmer decision, but it's a quote from the Bruchmer decision where the Bruchmer decision is saying that it is not that this is the misunderstanding of the 16th Amendment. This is the mistake, the erroneous proposition that Bruchmer brought to the court. So this circuit court, this 8th Circuit Court, our second highest court in the land, one of our second highest courts in the land, you can't have just gotten this wrong. You can't read Bruchmer and anything about it and misunderstand it. This is a lie. This is just an outright lie about what the Bruchmer court says. And at the same time, it's an acknowledgement that the Bruchmer court is the standing authority on the nature of the income tax, because if it wasn't, the 8th Circuit would not be referring to the Bruchmer court as its authority for what it is that it's trying to say here. It would be referring to whatever was the latest and greatest treatment of the tax. Bruchmer remains the law, and the 8th Circuit is willing to lie about it. On its website, and in many of its publications, the IRS makes this same false claim. In this case, now citing another circuit court, making another bogus statement about the Bruchmer court. This is what the IRS has on the webpage. You can see there at the bottom. The courts have both implicitly and explicitly recognized that the 16th Amendment authorizes a non-apportioned direct income tax on United States citizens, and that the federal tax laws as applied are valid. In the United States versus Collins, I'm sorry, 10th Circuit, I said 11th Circuit, 10th Circuit, The court cited Brushemer versus Union Pacific Railroad and noted that the U.S. Supreme Court had recognized that the 16th Amendment authorizes a direct, non-apportioned tax upon United States citizens throughout the nation. An outright lie. This is an outright lie. These false statements of the Brushemer ruling, which are not, it should be noted, mere misconstructions or even disagreements with what the court says, but rather are false ascriptions to the Brushemer court of declarations which are not only the exact opposite of what Brushemer says, but are what the court expressly says is not true, have been used to justify applying or enforcing the income tax upon unprivileged earnings or the activities which produce them. This resort to falsehoods and deception powerfully emphasizes the fact that no actual authority exists for the application of the tax to unprivileged earnings or activities, and that instead such applications are prohibited. Further, of course, the more than 250,000 concrete admissions by the IRS and state tax agencies made over the years, how many people here have received victories, gotten their money back for making use of what they've learned in cracking the code? All right, we have some hands up. This is good. You're part of the 250,000 concrete admissions by the IRS and state tax agencies made over the years since the foregoing information about the tax was first compiled and published in 2003 emphasized even more strongly the invalidity of applying the tax to unprivileged earnings. Such admissions against interest reveal in the most compelling way possible that the government that posts and cites to falsifications about the Brushemer ruling in hopes of perpetuating a desired revenue stream knows better itself, and will admit it when the demand is properly made. This little note is not so much for the group here, but for those people who are going to end up seeing this video later. For a more in-depth introduction to the legal realities of the income tax and how it came to be widely misunderstood and eventually lied about by certain federal officials, see losthorizons.com, the 16th.htm, very instructive and easily digested model of the income tax application structure, revealing how the tax has been successfully misapplied on a wide scale over the last 75 years or so, can be found at losthorizons.com, bobsbicycles.pdf, but we're going to go through that one in just a minute. And the complete revelation and analysis of the tax can be found in the book, Cracking the Code, The Fascinating Truth About Taxation in America. Okay, in a moment, we're going to hear from Greg Sutton. And I'll preface this point right now with the fact that Greg intended to be here and make a presentation in person, as I had asked him to, but he had an eye emergency come up and was forced to be right now in surgery, having some work done on his eye. So he very kindly produced a little video of his presentation, and we're going to see that in a moment. But I want to say before I hit the button on that one, even those of you that are a number of years immersed in this subject and are familiar with it, not here for the first time by any means, I want you to take in what we've just covered here in this for this purpose and in this sense. You need to all know, you need to know 100% that what you understand about the tax, your knowledge of the tax, is correct. That correct knowledge is going to be subject to, and you've all experienced it being subject to attack, to skepticism, to division even in some cases. As to how could you believe that? You know, how could that be true? How could that be true? That's just crazy talk. How could that possibly be true? And in some cases, official resistance, acting as though it wasn't true. You've been subjected to these things, and you're going to be subjected to these things. And it's really important that you have living inside you the certain, absolute certain knowledge that what you know and believe about tax is in fact correct. It is in fact correct. I go over this stuff over and over again when I talk to people, even people like many of you who know a great deal about this already, who read this stuff several times already, whatever, because the forces that don't want to admit the truth. Think about what's at stake here. Remember we looked at that hockey stick a while ago? Everybody remember that hockey stick? That hockey stick represents trillions of dollars. Trillions with a T and an R. Trillions of dollars that go into other people's pockets, that come out of your pockets and those of all your neighbors, and go into other people's pockets. And those other people really don't want you to know the truth about the tax. They don't want your neighbors to know the truth about the tax. They dread the idea that you will go in confidence into the world and teach other people the truth about all this. Because when you do, they stop getting those trillions. And you keep those trillions. You and your neighbors and your friends keep those trillions. The way the founders intended you to. The way the founders meant for you to do. And the way that is your right. It is your right. You earn the wealth. That wealth belongs to you. When that wealth is taken from you, it is used for bad purposes, more often than not. And in any event, even when it's used for good purposes, it skews the activities of the country into political things, because that's where the disposition of wealth operates at that point. When it has, gotten into the hands of a political event, political class or political phenomena, then instead of doing things efficiently and properly and smartly, you have to do things politically. You have to do things that give you access to the political levers and influence. Then it becomes a matter of not what you know, but who you know. And so we go from being a society of accomplished people, people who make things, people who know things, people who do productive things, to people who pander, to people who control the output of people who produce things and do things. It's a despicable structure when the politics thing becomes more important than the productive thing, because the politics thing has lied its way into control of the resources. It's a horrendous thing. So you've got to go forward knowing that you are right and able to explain that, to express that to other people with 100% confidence and 100% ability to say, oh, well, what about, what the Eighth Circuit says? The Eighth Circuit says it's a direct non-apportioned tax. And you've got to be able to say, you know what, I know, how much we are all conditioned to imagine that those, solons in black robes that, are elevated into these life-tenured positions are like the, virtual word of God on all things, legal or whatever. But you know what? Some of those people are lying scumbags. Some of those people, they know less about it than I do, perhaps. And if they don't, then they are just simply outright lying. And they are attempting to subvert the constitutional structure. They are attempting to subvert the rule of law. They are attempting to tyrannize you. It's important stuff. You got to be able to talk about it with confidence and knowledge, and be a storm, be a force out in the world. Okay.
I have a quick question. In the Eighth Circuit decision, was that one individual or was that a group of judges?
One individual. Oh, well, no. That was a panel. It was a three-judge panel. And at least two of them will upheld that statement.
Was that ever challenged to the Supreme Court or anything, or was it ever rebutted?
I can't say necessarily. In one of the cases they mentioned that the ruling was cert wasn't granted in a challenge to the Supreme Court, but the Supreme Court not taking cert doesn't mean anything at all. The Supreme Court has actually had to say this over and over again over the decades. When they deny cert, they are not saying anything at all about the merits of the case. They're just saying, we got to, there are only so many days in the week. We get 10,000 petitions a year, and that's what the number is, by the way, literally 10,000 petitions to the Supreme Court. They ruled on about 80 cases or 90 cases total in a year's time out of 10,000. So they pick and choose. They pick and choose the stuff that seems most significant to them, or most politically important to them, or most turns them on the most, or whatever. It is by no means, when they deny cert, it doesn't mean anything else. And they have specifically said this. They have written in rulings saying, we have to remind counsel, as we have said many times before, our denial of cert means nothing. Because everybody likes to, if they have a case that got denied cert, and it's a case that they like the outcome of at the lower court level, and the Supreme Court denied cert, they all like to say, oh, cert denied by the Supreme Court. See, they affirmed us is what they mean to say by that. That is not an affirmation of anything. And we saw that in one of those rulings just a moment ago. The one that the IRS likes to quote, the United States versus Collins. And they say, you know, cert denied, like as though that means something. It doesn't mean anything. It itself, to say that is itself a lie. Because it is meant to imply to you that the Supreme Court upheld what the Collins Court says. The Supreme Court did not uphold what the Collins Court says. If the Supreme Court had taken the case and upheld it, nobody would be citing the Bruchner anymore. They'd be citing to the Collins ruling, cert denied. That's all that would be said by anybody from that point forward, because that would be the dominant case. That would be the case where the Supreme Court affirmed the Collins Court saying that the 16th Amendment created a direct non-apportioned tax. But they don't, because that means nothing, and that's just another lie. Everything in that little paragraph that is published on the IRS website about the nature of the tax is a lie. Which is another way of saying that, you know, the opposite of what is said here is the truth. Okay. So, Greg Sutton.
Hi folks, Greg Sutton here. I wish I could be there with you as planned, but my right eye here didn't cooperate. I promised Pete I'd present my research on the origins of Congress's power to tax political privileges, not wanting to disappoint, I'll attempt it from California. So here we go. The Constitutional Convention was called in 1787 because the lack of taxation powers that the government formed under the Articles of Confederation rendered it unworkable. The radical and idealistic attempt to create a functional federal government without taxation powers quickly gave way to a more practical and traditional approach to funding the federal government. When the founders gave Congress its powers of taxation, they relied upon customary and traditional ways of raising revenue that the mother country had utilized for centuries. The terms taxes, duties, excises, and imposts were familiar to anyone conversant in basic taxation principles and history. There was nothing radical or unproven about any of it, except maybe the apportionment requirement for direct taxes, but that direct taxation power was to be utilized sparingly, and the apportionment requirement did more to restrict the power than to enhance it. The overall familiarity with the terms duties, excises, and imposts was exemplified by the almost lack of debate in the ratifying conventions of the states regarding these powers of taxation. It was further stressed in the Federalist Papers that it was these types of taxes that would be primarily utilized to fund the operations of the new federal government. It was all well and good. But there was one type of excise that the common folk perhaps were unfamiliar with. That was the excise of political privileges. Since it rarely affected the common citizen, and the political actors that it did affect were more inclined to quietly suffer through its imposition than make a big stink about it. It remained somewhat of a secret, not told outside of political circles. Luckily, this particular subject of taxation, political privileges, had been reported upon and praised as an example of good taxation by several British writers, and their books happen to be quite popular in America. The first we'll look at is a book by John Sinclair, the first edition written in 1785, 2 years before the Constitutional Convention. He details various ancient revenue sources that the English sovereigns have used for centuries. One of them was from the political source, and I quote, "The sovereign of England was accounted the sole fountain of honor and office and of privilege. It will appear in the progress of this work that this prerogative yielded some profit to the exchequer, some monarchs disposing of offices for money, others making a sale of titles and honors, and in general, all of them demanding pecuniary returns for any privileges they bestowed, either on corporate bodies or individuals." Such clarity is hard to find these days. The second we'll look at is Blackstone's commentaries on the laws of England. This book was more popular in America than in England. It served as a portable law library for otherwise sophisticated frontiersmen living in the wild, settling legal disputes where no other legal resources were available. It was required reading for those seeking proficiency in the legal and business professions until World War I, when it was deemed anachronistic by the emerging progressive intellectual class. It was an immensely popular and oft-cited authority, rarely used by the founders in writing the Constitution and later the Supreme Court in settling constitutional disputes. I recommend that the entire chapter of the King's Revenue be read to better understand the evolution of taxation that took place over the centuries in Britain. But I'll just cover the office duty for now. And I quote, "The ninth and last branch of the King's extraordinary perpetual revenue is the duty upon offices and pensions, consisting in a payment of 1 shilling in the pound out of all salaries, fees, and perquisites of offices and pensions payable by the Crown." This highly popular taxation was imposed by Statute 31 George II, Chapter 22, and is under the direction of the Commissioners of the Land Tax. Another example of the subject matter clarity. So it is obvious from the historical record that those that received even a slight modicum of exposure to public finance from the British perspective would have been exposed to the excise on political privilege. Yet despite its exclusive in-house nature, the educated early American had a good chance of being exposed to its existence and practicalities. When Congress finally did use the excise on political privilege during Lincoln's war to prevent Southern secession, less than 10% of the population paid it, and yet it raised more than a quarter of the total revenue raised by internal taxation. No one claimed that it was unconstitutional, i.e. a direct tax without apportionment, for the 10 years that it was imposed. Everyone involved with the excise knew that the centuries-long use of it by the British had established a precedent of its constitutionality as an excise that was beyond reproach. As Senator John Sherman exhorted in his speech of 1871, defending and praising the income tax, and I quote, "But it is said this tax is unconstitutional. It is enough to say that the income tax has been levied by the United States since 1863, and there is no court, so far as I know, that has pronounced the law unconstitutional. Certainly no United States court. No decision has been made of that kind. No dictum of a judge can be quoted to that effect, so far as I know. The fact that the question has not been presented and that we have collected under this tax $150 million from all kinds of people is a pretty good evidence that there is not much in the point. But if we look at the Constitution of the United States, I think that settles it clearly. The Constitution gives to Congress more power over the subject of taxation than almost any other. We have the power to levy taxes almost without limit. The only limit is that we dare not levy a capitation or other direct tax, except in a particular way. And we cannot levy a tax on exports. Now, is an income tax a capitation tax? It falls upon some individuals, but is not levied by the head, and therefore it's not a capitation tax. Is it a direct tax? I think the decision of the Supreme Court in the early case of the carriage tax, I have forgotten the name of the case, it was the Hyleton case, practically settles the question. The only direct tax is a tax on real estate and slaves. But it is not necessary for me to discuss a question of this kind, which is thrown in, as almost every law that is proposed is said to be unconstitutional. Any questions as to the origins of Congress' power to tax political privileges should be directed to the Lost Horizons Forum, and I'll be happy to answer them there. So now it's Pete's turn. Thanks for watching.
Okay, I said that we were going to go through that handy little model of how the tax works. About twice a month. So that's what we're going to do. I'm going to read it to you, basically. I want you all to do your best, follow along, pay attention. Anyone that wants to end up owning a copy of this, it is a part of my third book, was Grandpa Really a Moron? And you're welcome to take a copy home with you. But I'm going to give it to you here right now. The handy model of the American income tax scheme. Bob is a guy who lives down the street from you in a town that is really big on bicycles. Bikes get used for commuting, deliveries, shopping, etc. In fact, other than walking, bicycles are the exclusive form of transportation in your town. Your neighbor Bob has a by-the-mile bicycle renting business, Bob's Bicycles. Bob's Bicycles is far and away the biggest business in town. Part of Bob's success is because he does a lot of contract business. However, Bob doesn't just get paid by riders who have signed an agreement with him, or even just those using Bob's bikes. Bob gets something every time anybody in town does any riding at all, through an odd combination of circumstances that took many years to come together. Here's how it happened. Bob's Bicycles was launched long ago by the great-grandfather of the present Bob, Bob IV. Great-grandpa Bob started out not only with a main location for his contract business, he also had the bright idea of setting up spots around town where he parked some of his bikes for use by the more occasional rider, on an honor system. Anyone could take and use one of these bikes, but they were expected to keep track of their mileage, and send Bob a 1040 mileage-ridden rent due form, and the appropriate rent, periodically. The initial design of the form was like this. I, blank, rode a Bob's Bicycle a total of X miles this year. At Bob's rental rate of 15 cents per mile, I owe Bob whatever. I said that great-grandpa Bob planned to deal with these occasional riders on the honor system, and that's true. But he liked his money, too, and didn't want to miss anything that was due him. So after setting up the self-serve locations, great-grandpa Bob went around handing out W-2, 1099, or K-1 rider reporting forms to every other business in town. The forms, accompanied by notices that if Bob didn't get his rent from someone riding a bicycle in connection with any business, he would sue the company involved, said, I, Joe Smith, whatever, saw Tom Jones riding a bicycle from here to here on such and such a date. I swear this to be true to the best of my knowledge and belief under penalties of perjury. Signed by. To begin with, everybody understood that where it says bicycle on one of Bob's W-2, 1099, or K-1 rider reporting forms or notices, it means one of Bob's bicycles. For one thing, this was obvious. After all, what legitimate interest would Bob have in getting a report about someone riding a bike that wasn't his? Indeed, what business would Bob have even asking for a report about someone riding a non-Bob's bicycle? Everyone understood. And besides, on the back of the form, anyone who looked would find, when used on one of Bob's forms or notices, bicycle means one of Bob's bicycles. So these forms worked well enough to begin with. Everyone understood what they were for, and Bob's honor system bicycles were all painted bright red, so mistakes were few. Some mistakes did happen. So Great-Grandpa Bob provided that the same reporting process used to admit riding a Bob's bicycle on the honor system would serve to correct any errors. All that a victim of an erroneous W-2, 1099, or K-1 rider reporting form needed to do was fill out one of the 1040 mileage-ridden rent-due forms, which could be conveniently found at the Bob's bicycle locations all over town, declaring the truth of the matter, with a specific rebuttal or correction of the erroneous W-2, 1099, or K-1 rider reporting form assertions attached. This might mean reporting that they had ridden 0 miles on one of Bob's bikes that year. Or it might mean acknowledging that they did ride one of Bob's bikes for a certain number of miles, just not the number reported on the erroneous W-2, 1099, or K-1 rider reporting form. This particular use of the 1040 mileage ridden rent due form led to a little change in its design. Now it looked like this. I, Joe Smith, rode a Bob's bicycle a total of X miles this year. Since Bob's rental rate is 15 cents per mile, I owe Bob blank. Under penalties of perjury, I declare the foregoing to be true, complete, and correct to the best of my knowledge and belief. Great-Grandpa Bob was a nice guy and he was comfortable with his honor system, but Great-Grandpa Bob wasn't born yesterday. Over the years, things got a bit more complicated, just by an unfortunate coincidence of several misunderstandings. For one thing, Bob Jr. stopped personally distributing the W-2, 1099, or K-1 rider reporting forms, and hired a company to take care of this for him. Now, folks who had never even met Bob, and didn't know anything about him or his business, started getting W-2, 1099, or K-1 rider reporting forms in the mail. Along with the forms came prominent instructions advising the recipient to use this form to report the use of a bicycle by any person. But note that when used on one of Bob's forms or notices, bicycle means one of Bob's bicycles, got reworded into more complex legalese and buried in a whole lot of new fine print on the back of the form. Later, that clarifying note moved off the form entirely, first being replaced by a cryptic reference to where the definition might be found in the Bicycle Forms Publications and Policies Guide, conveniently available at each Bob's location around town. And then ultimately being dropped altogether under the principle that knowing what the forms are for is the responsibility of the person filling one out. Unsurprisingly, a lot of folks misunderstood and began filling out and sending these reports to the address provided every time they saw anyone riding any bicycle. Another thing contributing to complications with Great-Grandpa Bob's program was Bob Jr.'s decision to stop painting his honor system bikes bright red. Pretty soon, even folks who remembered that W-2, 1099, or K-1 rider reporting forms only related to Bob's bicycles were filling them out anytime they saw anyone riding a bike. This was only partly out of confusion. Bob's had become a very successful business over the years and was an important customer to every other company in town. People were eager to please Bob and keep in his good graces. Furthermore, although the fine print on the W-2, 1099, or K-1 rider reporting forms had changed, those notices about Bob suing for his money had not. Bob maintained a really active PR department and was well thought of in the community in general, but he also had the most aggressive collections and legal operations in town. What with the subject of a report having a simple means of correcting any error, and in light of these other considerations, the simplest and safest course was just to fill out a report whenever anyone was seen on any bike. It wasn't long before the town's kids were growing up with the impression that Bob had some kind of legal interest in bicycle usage in general. After all, once they got jobs, the company they worked for would automatically fill out a W-2, 1099, or K-1 rider reporting form and send it to Bob, even when the kids rode their own bikes. If the rider didn't then send in the rent, Bob's collection agency would be all over them like ugly on an egg, with no questions asked. By the time the grandkids of the first Bob's Bicycles customers were coming up, everyone had heard stories about riders who, having not paid Bob, were hauled into court and accused of bicycle rent evasion. All that ever was alleged in those cases was that the accused rode a bicycle and hadn't paid Bob. It appeared that if just these things alone were proven, dire consequences followed. Bob, it seemed, could charge you rent for using your own stuff, and the legal system would back him up. By then, it didn't occur to anyone, including the defendants in these affairs, that when used in Bob's Bicycles-related legal action, bicycle doesn't mean any bicycle. It only means one of Bob's bicycles, just as it does on a W-2 1099 or K-1 rider reporting form. After all, by then, almost no one alive could remember back to the beginning. By then, almost no one alive had ever read through Bob's Bicycle Forms, Publications, and Policies Guide, which had grown over the years to thousands and thousands of pages in length. Further, by then, Bob's Bicycles was so big and so rich and so diversified that Bob III had a hand in everything that went on in town and knew just how to spread all that rent money around. He had no trouble securing the support of the town fathers and other important and influential folks. And these movers and shakers, just as ignorant of the truth as anyone else, were happy to help Bob's PR department encourage everyone to just pay their rent without question. Paying rent to Bob became something to be done not only unselfishly, but with pride. Paying rent to Bob was good for the community. Over the years, every Bob has carefully kept the overall rent burden tolerable. The nominal rates have often been high, but a big list of discounts and credits has grown in place with the misunderstanding about who really owes rent to Bob. When everyone had understood and all the business done with Bob was knowingly voluntary, one simple rental rate was enough and no elaborate discounting was needed. And as more and more people found themselves seemingly beholden to Bob, he realized that if he tried to take the same rate from the less well-off that he could get away with from the well-to-do, somebody, faced with a bill they couldn't handle, might just start actually reading his Bicycle Forms, Publications, and Policies Guide, however difficult that had been made. Then the good thing Bob had grown accustomed to might fall apart. So Bob's rental rates have grown increasingly progressive. Bob, no dummy, is content to sacrifice on margin and make it up in volume. In his best move ever, Bob instituted a payroll deduction program, under which the townsfolk are encouraged to anticipate how much riding they're going to do over the year, and then have part of their pay sent to Bob each week against the annual rent bill they figure will result. By virtue of this program, most folks never even really notice how much they're sending to Bob. Bob is still chortling over this one, decades after thinking it up. Needless to say, Bob's 1040 mileage-ridden rent-due forms have gotten rather complicated, but whole industries have sprung up in town just to help people fill them out, for a fee, of course. The average person doesn't directly deal with paying Bob at all anymore. In fact, most get a refund from Bob each year of what had been over-deducted under the payroll deduction program, and view it like a birthday present. All in all, Bob has succeeded in creating the perfect storm of misunderstanding. Well, that's the story of Bob's Bicycles. Today, everyone in town plans all their affairs with Bob's piece of the action factored in. Indeed, big chunks of the population do nothing but handle Bob's Bicycles-related activities. Most of the rest can't imagine a time without the business Bob does with their own businesses, or the charitable giving back to the community grants Bob makes out of the rent money he collects. Great-Grandpa Bob rests, probably with a smile on his face, because the kids are doing all right. And deep within Bob's Bicycle Forms, Publications, and Policy Guides, the long-forgotten truth rests, too, waiting for anyone who will bother to take it out for a spin. So here's my question to you, knowing all that, who gave you your wheels? Okay, so let's review while enjoying some blues. find the truth about the tax matters. But before we do, take a little break. Give them a chance to stretch our legs.